These are some common headlines you would have seen in the past few years on your TV screens, in the newspapers, on the internet, and so on. And it makes sense because approximately 5,900 nonprofits had their FCRA registrations expire on December 31st, 2021. Either because they failed to apply for renewal before the deadline, or because the Ministry of Home Affairs refused to renew their license for suspected violations of the Act. But do you know what an FCRA license is, why it matters, and why it's been in the news since 2021? Stay tuned to find out. First, let us look at what is FCRA. The Foreign Contribution Regulation Act, or FCRA, is an act in the Indian Constitution which regulates the inflow of foreign contributors or aid to India. The law is enforced by the Ministry of Home Affairs. The intention behind the act is to prevent foreign organizations from dominating or influencing social, political, economic, and religious discussions in India. Entities in India are only allowed to receive foreign funds after obtaining the FCRA license. Non-profits have to apply for the same, while certain individuals and organizations are always prohibited from accepting any foreign contribution. These include political parties, government employees, print or visual media outlets, and so on. Now let us look at the history behind the FCRA Act. FCRA was first passed in 1976 after controversy over the possible use of foreign funds in parliamentary elections. The original act allowed non-profits to freely receive foreign donations, although they were required to report the amount received and spent each year. In 1984, the law was amended to regulate flow of funds to non-profits more closely. They were now required to register before receiving any foreign donations and prohibited from passing on that money to other non-profits who weren't registered. These modifications were made because of the government's perception that some of these organizations were being used by foreign players to channelize funds to political parties. The Foreign Contribution Regulation Act 2010, which is now in effect, was adopted in May 2011. It was then amended again in September 2020. The new changes state that organizations receiving foreign funds will not be able to use more than 20% of such funds for administrative purposes. Initially, this number was at 50%. The new amendment to the law also barred public servants from receiving foreign funding and made Aadhaar mandatory for every office bearer of the non-profit. Additionally, the new law also states that organizations that may not be directly linked to a political party but engage in political actions such as bandh, strikes, or Rasta Roko are considered to be of political nature, which prevents them from getting a license. Let us now look at the relationship between FCRA and non-profits. A non-profit must meet the following criteria to be eligible for an FCRA certificate. Number 1, the organization must be registered under an existing act of the Indian Constitution, such as the Societies Registration Act, Companies Act, or as a public charitable trust. Number 2, it must be in existence for at least 3 years. Number 3, in those 3 years, it must have undertaken activities in its chosen field for the benefit of the society for which it seeks foreign contribution. And number 4, the organization must have spent at least 10 lakhs towards its aim. However, after new rules were specified for foreign-funded non-profits in 2011, several FCRA registrations were revoked by the government. The primary reason cited for this was non-compliance with the rules, such as periodic filing of expenditure reports. However, this was seen as an attempt to ban dissent or protest. Human rights organizations faced the brunt of these cancellations as their work was classified as political and therefore ineligible to receive foreign donations. In 2014, an Intelligence Bureau report said that the foreign-funded non-profits were negatively impacting economic development in India. The report singled out Greenpeace, an international environmental non-profit, as a threat to national economic security. As per data on July 2023, there were 16,301 non-profits in the country with a valid FCRA license. FCRA licenses of more than 6,600 non-profits have been cancelled in the last 5 years for violation of the law. Overall, FCRA licenses of 20,693 non-profits have been cancelled till date. When it comes to the development sector, alliances and networks, collaborations, as well as mutual sharing of knowledge, research, and learning is extremely crucial. The new FCRA regulations can put limitations on this and impact research and development overall. Additionally, FCRA cancellations and sudden loss of jobs has also reinforced the precarity of working for a non-profit. As non-profits in India continue to lose their FCRA licenses, the impact is being felt sharply by their staff, the people they serve, and society at large.